Finding under a incorporation clause, generally accepted principles of international law are incorporated into Philippine law. Now to continue, I shoot this to you people. Just imagine the mental torment experienced by a foundling who does not know his or her parents at all from the moment he came to being, yet remain in a continuing loyalty and allegiance to the Philippines, to the culture of the Philippines. But the best thing you can reward of such foundling is to squeeze her scar of being a foundling to the extent of making him bleed again by restricting him the rights of a natural born citizen. I say the right thing to do under these circumstances is to show a little act of liberality by proclaiming him a natural born citizen. Now, citizenship is both of municipal law and international law, as I've said. Presumptions of law established by generally accepted principles of international law, which says that a foundling is presumed to be a citizen of the place where he or she is found and presumed to be born of the citizen of that country. That latter presumption is particularly applicable to countries which follows the jus sanguinis rule, like the Philippines, and to presume the otherwise, like what you are inclined to be doing, is wrong, and the wrong, my dear, shall never be presumed. Now, the concept of law that is embedded in our municipal law is going in our municipal law, which we can say that presumptions are already in our law, in particular with the rule on adoption issued by the Supreme Court itself, that foundlings can be adopted and the Court of the Philippines can decree their adoption only if foundling is presumed to be Filipino, because jurisdiction over the rest or the status of the child is determined by the nationality of the child before a court can decree the adoption of the foundling. A presumption has to be made that a foundling is a Filipino. And the presumption is that not only that he is a Filipino, the presumption is that he or she is a natural born. Now, because presumption, my friends, are based on common sense, human experience, ordinary course of conduct, the natural presumption is that newborn infant was never naturalized. He never underwent the process of naturalization, and under our laws, you have to be at least 18 years old to be naturalized. The more probable, more credible presumption is that that infant was born of a Filipino parents and that therefore a national born citizen. Now, bringing forth the issue at hand to the international setting, under the 1930 Hague Convention, to remind you, the principle is that each country has the authority to determine its nationals, and that determination shall be respected if it's consistent with international law. As I have mentioned, the 1934 Constitutional Convention, which produced the 1935 Constitution, in its deliberation acknowledged that citizenship shall be determined essentially on the basis of municipal law, but also on international law. Now, though this presumption might be disputable, it is not if the country is bound at all the time to say that a foundling is a natural born. But until the presumption is controverted, the status quo should be preserved, that foundling should be considered the natural born. Thank you.
For 7 minutes and 26 seconds.
May we call on the deputy speaker of the opposition side. Thank you.
Good afternoon, ladies and gentlemen, my teammates, our esteemed opponents, your honors, and to all the members of this most august assembly. First, let me make my rebuttals. First, government failed to dislodge its burden in providing a clear mechanism for this policy debate. Later, we are going to provide a better policy to address the call of this motion. Second, assuming arguendo that there is an ambiguity in the construction of the Constitution, we must construe it in favor of public interest, and this will also be addressed later in my speech. Third, the government continues on insisting in the presumption of nationality in accordance with the international law. However, they have forgotten to distinguish its international interpretation and domestic interpretation. Thus, we must harmonize their construction to be applicable in the Philippines. Chief Justice Warren says, in the case of Perez versus Brownwell, citizenship is a man's basic right, for it is nothing less than the right to have rights. Remove this priceless possession, and there remains a stateless person, disgraced and degraded in the eyes of his countrymen. And into this, we are graced with the motion whether or not to accord natural-born citizenship to foundlings. In light of the case at hand, our side capitalizes its opposition to the granting of natural-born citizenship to foundlings. In the progress of this debate, we must be reminded as to why there is a need to grant citizenship to foundlings. Why? So we go back to what Chief Justice Warren says, that it is a man's basic right. What are these rights? Political rights. Second, the right to participate in government, principally through the right to vote. Third, the right to hold public office. And fourth, the right to petition the government for redress of grievances. Stated differently, not granting citizenship to these foundlings deprives them of these aforementioned rights. Now, it is distinguished that there are naturalized and natural-born citizens. However, in the case of Shantek versus Republic, the Supreme Court, our Supreme Court, took a stand that other than for the purposes of election cases and for the petition for certiorari in immigration cases, other than for these purposes, this distinction is without significance, and that a naturalized citizen is entitled to similar treatment as a natural-born citizen, except where the Charter itself provides otherwise. Thus, the opposition tilts the motion in favor not only of the foundings but also to the interest of the public. We propose a counter policy that is to amend the CA 473, and I hope you are aware about that. That is the revised naturalization laws of the Philippines. And then we want to integrate there in the circumstance, we want to integrate there in the circumstance of founding for their protection and grant of rights, because they do not have the right. They are not given rights because they are stateless, right? Which is also in harmony to the intent of international law. What is the intent of international law? To grant these foundlings rights which is deprived of them. That is to, meaning an amended CA 473 will vest Filipino citizenship to foundlings as naturalized one, without prejudice to the possibility of them having proven their natural-born citizenship. Now, I present to you the repercussions of what they are proposing. We back on this counter policy because first, it is not costly, second, it is efficient, and third, it is more practicable. In contrast to vesting these foundlings the status of a natural-born citizenship, which is the call of the motion, right? And now the question is, on my first argument, in the integration of these three, its costlessness, its efficiency, and practicability, it can address and troubleshoot the problem at hand. Because CA 473 is one statute later, is one statute in comparison to, it is only one statute in comparison to the Constitution, which is the paramount law of the land, which governs all laws of the land. An amendment of CA 473 produces no effect, or if there is, less glaring effect. Less glaring effect to the Constitution, which is the supreme law of the land, as I mentioned earlier. Later, on the other hand, later. On the other hand, an amendment of the Constitution, apart from the rigorous and time-consuming process, I hope you will listen, apart from its rigorous and time-consuming process, which we all know, it will also result to an amendment of various laws, like election laws and laws governing public officials, right?
Point, please.
In other words, constitutional amendment later does not produce domestic. Second. In other, constitutional amendment does not only produce domestic effects but international effects. This is in support to the legacy on how the framers of the Constitution, draft and construe our Constitution. Our constitutional framers particularly inscribed therein natural-born citizens to protect the interests of the people from dual allegiance. This is in line to the premise that the issue of citizenship is at stake, and our Constitution cannot afford this issue, which will evidently cause conflict of interest in the international arena. Your point, please.
We are backing on presumption. I'm sorry, I'm not allowed. We'll reserve it. Thank you.
Question?
What?
Your time is up.
Okay, wherefore premises considered, we pray that this debate be adjudicated in response to the call of the motion, and second, that the mandate of the Constitution be upheld. Thank you.
We would like to welcome the chief speaker of the government side.
Good afternoon, judges. Good afternoon, Your Honors. Good afternoon to our opponents and to my members and to all of the members of this House. Now, before I go on laying down the issues and rebuilding the arguments that we have, let me just say that why would we go for another mechanism which the opposition has proposed, which is somehow costly? We are banking on the presumption that a foundling shall be presumed to be a natural-born citizen, and any decision would then give him that natural-born status. Okay, that is just what I wanted to point it out. So let me go on with the issues at hand. The issues in this debate should be set in the context of the real world, in the context of international laws, and into our constitutions. The questions here are whether or not a foundling with unknown parents, since birth, be deprived to be a natural-born citizen, or shall he or she be presumed to be a natural-born citizen? In addition, whether or not the state has the obligation to pursue or pass into legislation a law that would accord a natural-born foundling in protection of their fundamental rights, and whether or not the Constitution be interpreted to presume foundlings to be natural-born citizens in the absence of proof or evidence to the contrary, and whether or not declaring a foundling to be a natural-born citizen would produce more harm than good. So, in light of this, we must resolve these issues by not limiting our decisions to the letter of the law. Because a great judicial mind, in accordance with great associate justice, does not limit itself to the confines of the strict law, but it somehow entertains judicial decisions internationally that would somehow be for the benefit of the interest of the people. And we should not base our interpretations to selected provisions of the Constitution to disprove a question of an application of a fundamental law. Rather, we must adopt an interpretation in its entirety, considering other constitutional provisions which are of equal importance. We have due process, social justice, and human rights. If I could, I would somehow quote the famous Justice Laurel in saying that, with full conviction, social justice is neither communism, nor atomism, nor despotism, nor anarchy, but the humanization of these laws and the equalization of social and economic forces of the state, so that justice, in its rational and objectively secular conception, may at least be approximated. So, by the words of that, these laws should be interpreted and be humanized to our own benefit. Because what the opposition failed to point out, what the opposition failed to do is that they have limited their resources to internet articles and to the strict letter of the law. In addition, they also have failed to point out the possible harm of declaring a foundling to be a natural-born citizen, in which we would somehow point out in our arguments later on. So, continuing, as a contracting party to the Convention of the Rights of the Child, the Philippines has the responsibility to somehow pass upon legislation to protect these rights of a foundling. The right to acquire Philippine citizenship as a natural-born citizen. We have the Convention of Rights of the Children, which recognizes the need for legislation for the child to acquire nationality of a contracting party, and recognizes that if implementing legislation is not passed, a child could somehow be stateless. And we should take cognizance of the Universal Declaration of Human Rights, which is somehow adopted by the Philippines in consideration of Article Section 2. That every child shall be registered immediately after birth without having to go through naturalization, and shall have a name. That every child shall have the rights to acquire nationality. The Philippine law must be interpreted as to avoid statelessness in accordance with these international laws that are binding. And in addition, to say that foundlings are stateless persons is a violation of these international law-binding treaties. Next, I will go on further. That a foundling should be presumed to be a natural-born citizen in the absence of an evidence disputing it. The presumption of law should be in favor of the child or the foundling for his best interest. That the burden of proof lies on the one disputing it. In addition to that, our adoption laws presume that foundlings are natural-born citizens by mere registering these children as Filipino being adopted, thinking that these are Filipino citizens. So, continuing my third argument, the 1987 constitutional provisions and statutes on due process and human rights can only be interpreted to mandate the government, including the courts, to always interpret the law from the best interest of a child. And if there is any ambiguity with the provisions of the Constitution, as I've said a while ago, we should always go back to the purpose in which it was written, and which will be found in the preamble. Because that is how our Constitution is somehow written. That is how our Constitution is somehow built upon. If I would somehow read in the preamble, let me just read it, so that you can internalize our points. We, the sovereign Filipino people, imploring the aid of Almighty God in order to build a just and humane society and establish a government that shall embody our ideals, aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and our posterity the blessings of independence, democracy, under the rule of law, a regime of truth, justice, freedom, love, equality, and peace do ordain and promulgate this Constitution. And with that, I end my speech. Thank you.
4
Let's
seconds.
welcome the whip speaker of the opposition.
Opposition.
Honorable adjudicators, fellow debaters, distinguished faculty members of the College of Law, a pleasant afternoon to all of us. Ladies and gentlemen, it is very easy to get swayed by the outpouring emotions displayed by the government as well as their supporters. But then again, may I humbly remind this honorable House, that the fact of the matter is this is a policy debate. The point of this debate is who among your houses offer practicable and reasonable policy and mechanism to address the problem. So, I would like to rebut the argument of the last speaker. First, she said, I would argue that such presumption that foundling should be presumed as a natural-born citizen is not permissible because it has to be expressly provided for in the Constitution, and that's very clear. And it's not expressly provided for by the Constitution, and therefore they cannot presume that foundlings are automatically considered as a natural-born citizen. I concede to the fact that, yes, of course, it is violative that foundlings will be stateless. But then again, they fail to recognize that the government, as parents patria, has provided already the benefits or the safeguard, the safety nets to those foundlings. First, before if a foundling has to be registered, she or he is given a foundling certificate, and that founding certificate tantamounts to being a citizen to the Philippines. And I repeat, being a citizen to the Philippines, but not a natural-born citizen.
Here.
So this brings us to the issue at hand. The issue is whether or not families would be accorded with a natural-born citizenship. The opposition strongly argue against the proposal of the government, even mocked on the outfit of my able here. But then again, because of the failure of the government, your opposition offered a counter-proposal. A counter-proposal because of their failure to present this very concrete and a black and white proposition to end this problem or this issue. Ladies, it has already been elaborated by our second speaker. In fact, she very well stated that what would be the mechanism that would be employed with the opposition in order to address accordingly the problem of the families. And then again, they failed to rebut on that matter. Ladies and gentlemen, we have heard the government's paradigm. First, the first speaker presented that we have to presume that the foundings is to be considered as the natural-born citizen. Again, that is very problematic. That is contrary to the law provided for in the Constitution. And we all know as law students that in any proposal that is in contravention with the Constitution, it should not be considered. First, they failed to provide a concrete policy proposal. We, on the opposition side, waited for the second speaker, because that is in fact his job, to present a very concrete support to the proposal of the first speaker. But then again, he failed to do that. But he made mention a lot of the treaties, and he even made mention the deliberation in the 1934 Constitutional Convention, and yet again failed to emphasize that during that deliberation, there's an important deliberation that he missed out. It was indeed presented in the deliberation to consider the status of the founding. But then again, they said it's no longer applicable, but because during that time, it's not applicable, it's not yet timely as of that moment. But they voted because they considered the status of the foundings. Third, the mechanism they wanted to adopt, in fact, there was indeed no mechanism at all that they tried to present to the opposition. They wanted us to sway, to concede with the proposal, but there's a problem, because as citizen of this country, we have to clearly study or be critical to whatever proposals that the government is trying to offer us, because it will affect our future, it will affect the benefit or the welfare of the people. Then the mechanism they wanted to adopt offers more risk, presenting that we have to presume that I think the third speaker not allowed to give you a point of information.
Argument yun na.
You may.
Pwede.
You're saying about the mechanism, so I'll go further in that. Can you wait?
No. The mechanism that you're somehow proposing, is this even viable and pragmatic?
I will go on to that. So thank you for that point. The opposition failed to present a mechanism that would offer. In fact, the proposal stated in the presented by the stated by the first speakers. We have to presume that that the foundings are natural-born citizens, and yet she did not. And the second speaker did not elaborate what would be the implication to the laws provided in the Constitution, the implication in our election laws, the implication of our those elected officials that has to be considered to be a natural-born citizen. It has an implication. What they're doing is presenting a proposal, and yet they fail to conduct or to give a mechanism. What if in the near future there will be conflict of laws on that matter? Okay, proceed, sir. The problem of the government's paradigm is that they wanted to evade from the very basic understanding of the application of the statutory construction.
Sir, start mo na.
Sheer knowledge.
Yes.
Sheer knowledge.
Okay.
You're saying that we don't have mechanism. Presumption is the mechanism.
Yes.
The one you're proposing a policy, that's
We
really.
cannot undertake
I'm sorry, sir. That time is up. Because you first presented that we have to consider that the foundings are natural-born citizens, and yet it's like opening a Pandora box, presenting of presuming that the founders are natural born citizens has an impact or has an implication to our election laws, to other pertinent provisions in the Constitution. That is what we're trying to hear, or that is what we wanted to hear from the government, and yet they haven't provided the opposition and this noble assembly any distinct and any concrete proposal in that matter. That means to say that their proposal doesn't hold waters. Now, your opposition concluded that the notion that the foundings are to be given safeguard. In fact, it is not only the rights of the foundings that the government is trying to protect in this matter. In fact, ladies and gentlemen, what the opposition is trying to uphold is to defend not only the right of the foundlings and the other citizens, but the supremacy of the law, the supremacy of the Constitution. It is therefore the strong position of the opposition that to accommodate the foundings as proposed by your government, instead of waiving the provision of the Constitution with respect to natural born citizens, it is practicable and legal that the Commonwealth Act instead will be amended to give effect to the naturalization of the foundlings by operation of law. Upholding the law has always been a fundamental element in the vital fabric of any well-functioning state. Thank you.
Cross House as speakers.
And it's a sign of sportsmanship and shake our hands.
Another round of applause for our speakers. That was a very exciting debate. It is some sort of great importance because our country today is facing such controversy,